Hi, everyone. This is Matt Crisafulli with ACap Advisors and Accountants. This is a webinar on estate planning and what's involved in estate planning. I think people hear the term and they don't quite know what it means. And because of that, they just sort of put it out of their mind. But hopefully, we'll be able to help clarify that term a little bit over the next hour or so and leave you with a better understanding of what estate planning is and why it's an important component of a financial plan and overall just, individual security. As I said, my name is Matt Crisafulli. I'm with ACap Advisors and Accountants. We are a boutique fee-only wealth management firm, and we also are a CPA firm. We do tax and accounting work for our clients as well. As an important component of a financial plan, we do advise and refer for estate planning. And if that term is foreign to you, we'll clarify that a little bit more in the next an hour. So what's involved in the estate plan and so on, and how it intertwines with financial advising. So without further ado, I'd like to introduce Armine Bazikyan of the Bazikyan Law Group. She is a fantastic estate planning attorney and also does trust administration. And she is a super lawyer rising star from the years 2013 through 2019. And I have no doubt that she'll achieve that recognition year over year as long as it is awarded. So Armine, if you don't mind telling us a little bit about yourself and your firm, and then we'll get started.
Sure, Matt. Thank you for having me. As Matt mentioned, our firm focuses exclusively on estate planning. So we handle everything from basic wills to complex trust setups. And we also help those same clients and other clients administer those trusts when time comes, whether they've passed on or it springs to life through some other condition. And we also administer probate estates as well. We serve the general Los Angeles area with offices in Glendale and Sherman Oaks. So we cover both the San Gabriel Valley as well as the San Fernando Valley.
So a couple other a couple other housekeeping things. I have accounting on the brain, I'm sorry. Housekeeping things before we get started. We will be recording the webinar and we'll post it on our website, which is listed here for use. You can review it in the future if there's something that you missed, or you can share it with a friend or a colleague if you think that they'll find the information valuable. And the last thing is that there's a Q&A box at the bottom of your screen. Feel free to click on that and submit your questions, and we'll have a Q&A section at the end of the webinar to answer any burning questions that you might have about the topic.
So let's get started. I'm going to jump in, Matt. So today we're going to try to cover a lot of material, and my goal is to give out as much general information as I can, and then leave all the specifics to another time. But I would really want the listener to get a really good feel for what estate planning is, how it works in California, and then we'll touch on some different types of assets and how they actually play out at death. So we'll be covering the basic wills and trusts planning process, the probate process. We'll touch on guardianship nominations, because as I understand, you have quite a lot of younger couples coming to you for financial planning, and this is an important topic to parents of minors. We'll talk about living trusts. We'll talk about life insurance and how that can play a role in your estate plan. And then as you mentioned, we'll have a Q&A section at the end. So I want to start off with the general foundation. I want to lay a general foundation for the listeners in understanding exactly what probate is, or what the law is in California. So in California, our law that controls what happens to assets of a person when they've passed on or they're very, very sick and can't control them themselves. The probate code is the law that controls those scenarios. And so anytime when someone has passed away, we always ask the question, did he die with a will or without a will? Now, the funny thing is that regardless of which road was taken, whether the person prepared a will or didn't, they still end up in probate court. And this is one of the misconceptions in the public. A lot of times people will come to me and say, I want you to create a will so that it doesn't go to probate. And I have to educate them and say that is absolutely false. If we create a will, as you can see from this chart, if you die with a will, you're still going to end up in the probate court system. If you die without a will, you're still going to end up in the probate court system. And the real difference between these two is that if you're putting together a will of your own and you end up in probate, the judge will read what you have requested and follow your instructions about who inherits from you. Whereas if you do nothing at all, if you haven't written down your wishes, the judge is not going to know what you wanted. So they'll turn to the California probate code and the intestacy laws, and that will tell them who is the next in line to take from your estate. So generally speaking, intestacy laws in California kind of trickle down the family tree. So it goes, spouse, children, grandchildren, or if you're not married and don't have kids, it kind of goes parents, siblings, grandparents, aunts and uncles, cousins. And so it goes all the way through your family tree until there is no one left. And at that point, it goes to the state. It escheats to the state. That's the legal process. Which is another misconception. Sometimes people will come to my office and say, I need to create an estate plan because I don't want the state of California to get everything. I want my children to get it. And we have to stop and say, well, the state of California is not going to take anything from you just because you haven't done planning. They only take if you have absolutely no living relatives. So it's a formal process. This probate court process is actually a court case that's opened for the deceased individual. It's a formal court proceeding on average in California because we're so inundated. The courts manage these cases with a turnaround of about 1.5 to 2 years, depending on how simple or complex it may be. And this is assuming that nobody fights, all the relatives are on board, everything is in agreement. If there's one little hiccup, that timeline is extended by months and even years. It's information that is public. So your nosy neighbor, Nancy, sorry to all the Nancy out there. I don't mean that Nancy's are nosy, but all of those, curious people out there will be able to just tap into the court system and download information about what type of assets you had, who's saying what about which assets, what you wrote in your will if you have one and whatnot. And then finally, the most important reason why we as attorneys want to avoid the probate process is because it is extremely costly in California. The probate statutory fees, the attorney's fees, are written in the law. They're statutory, meaning it has already been delineated what amount gets paid to the attorney. So if we look at this chart, so if we look at, let's say, the cost of probate, and this is a really good example because I think it highlights the fact that you don't have to be very wealthy to realize how expensive the process is going to be for you. So in this scenario, Darcy passes away and she had a home valued at $500,000 and it had a $300,000 mortgage, which means that we only have $200,000 equity that we're trying to squeeze out to the beneficiaries, to the heirs. And then she had $200,000 in cash at a bank. So if you notice, probate does not care if you have liabilities on assets. All they're concerned with is the value of the actual asset. So they don't care about that mortgage. They're going to use that 500 number. And the reason why this is important is because they actually base the value of the attorney's fees on this little chart that we have in the right-hand corner of percentages. So the first 100,000 is charged at 4%, and then you can see it adds up. So for this particular estate valued at about 700,000, the attorney fees alone, statutory, meaning you're not negotiating them, they are set in stone, are going to be about $17,000. In addition, whoever the family member or friend is that is the executor or the administrator is also entitled to an administrative statutory fee for the work that they're doing. And that's equal to what the attorney gets. So that's another $17,000. Now, a lot of times family members won't take an administrator fee. They'll waive it, which is great, but the attorney fee is still there nonetheless. So at minimum, we're looking at $17,000. Then there's the court filing fees, publication costs, bond insurance, which is normally required unless it's waived by the deceased individual. recording fees and other miscellaneous costs. So it really adds up, and for a measly, I say measly 700,000 because I think if you just own property in LA, you're already at this 700 number. Your family members will be set to lose out about 35 to 40,000 very easily. And this is assuming they don't sell the property during the probate process. There's nothing complex that happens. If there's anything extraordinary that happens during that probate process, the attorney is actually entitled to charge an hourly rate. So for example, selling the property during probate can add on another couple of thousand in just attorney's fees. So as you can see, super expensive. We want to avoid this cost. And we'll talk about the way we do this later, but that avoidance, there's already some things in this world, in the finance world, that automatically avoid probate without you having to do anything, right? So there's certain types of accounts that don't go to probate. One of them are beneficiary designated accounts. So anything that you have a beneficiary designated on will trump the probate process. It'll bypass it. So for example, if you have a life insurance policy and you've named your mom as a beneficiary, that money will not go to probate. It'll automatically be distributed to your mom by the life insurance company after you're gone. There are exemptions to that. So minors, if you name a minor on a life insurance policy, even though it's beneficiary designated, because they're minors and they're not going to be taking that money until 18, the court will require you to set up, well, the life insurance company will require you to set up a guardianship through the court before they release that money. Or if you have a scenario where no beneficiary was named, sometimes it ends up in probate in those cases. Or my favorite mistake that I see within the life insurance world is if an owner of the policy dies, but the insured is still living. So nowadays we have life insurance being used as an investment tool, where let's say parents will buy a $100,000 policy on their child, and the child is the insured. And then lo and behold, parent dies. Parent was the owner of the policy. So now all of a sudden that $100,000 policy is actually an asset belonging to the parent. And so we want to make sure that that doesn't end up in court, depending on the amount that it is. And I see this a lot with individuals owning policies on their parents. So, and we had one recently where the individual passed away and he was the owner of a $300,000 policy on his mother, and the mother was still alive. So that $300,000 policy as the owner actually trickles down to his family members, his children. But in order to do that, we needed a probate order. So be very careful about what type of accounts you hold, because not all of them bypass that probate process. Real property, real estate is one of the reasons why people end up in probate court. So depending on how you hold title to your property, you may or may not end up, the property may or may not end up in the probate system after you're gone. And then also, of course, the way you take title to property also impacts your taxes for your successors in the future. So I want to go over just a couple of examples just to highlight the different types of property ownerships that we have in California, and then how it impacts how the probate system impacts it, and what result will occur after your death, and then what tax implications that particular method of owning property has for your loved ones. So the most common one we have here in California is joint tenancy. I think by default, a lot of escrow companies and realtors will just recommend joint tenancy to their clients without really knowing the tax implications. The reason, so joint tenancy from a definitional standpoint is when two people or more own property together. They don't have to be married. They don't have to, have any type of relationship. So it could be John Smith and Joseph White. They're best friends. They're both single men and they own a property jointly as joint tenants. Or it could be John and his wife Jane, who are husband and wife, and they own the property as joint tenants. So there doesn't have to be a familial relationship between the individuals. It just has to be two or more. Whenever you see the words joint tenants on a deed, on title to property, that automatically for the legal world means that when one person is gone, everything goes to the other person. There's a right of survivorship presumption, which means that if John passes away, his property that he owns jointly with his best buddy is not necessarily going to go to his wife and kids. It's going to end up with Joe. He's going to be the rightful owner. Okay. So this is a very particular vesting, and it works with only certain types of individuals, as you could sell, but there's no probate administration. And that's one of the big perks and the big reasons why we see people recommending it all the time. There is no probate proceeding. Of course, if both of them, like John and Jane, die together, then yes, absolutely, it's going to go to probate. But for one death or first death, it avoids the probate process, and the remaining person, last man standing, gets the whole apple. That's what we say. The negative of it, even though it avoids probate, the negative is for capital gains purposes. When we have a husband and wife, we can't take advantage of a full capital gains step up. And that causes the surviving spouse to lose out on a lot of money when they're ready to sell and downsize, or ready to move to another property. And then what I call accidental disinheritance is actually pretty common as well, which is another negative. So we have, let's say, John and Jane, husband and wife. John dies, Jane inherits the property. It's just her name on the deed. And then she dies. And so it goes to probate, and Jane's heirs at law inherit from her. And if Jane had 2 kids that, didn't belong to John, and John had children from a previous marriage, we have a scenario where John's kids legally are entitled to nothing, and only Jane's kids get it, just because their mom died second, which is really unfair in the system and in the scenario. But it's just an accidental disinheritance that happens all the time, and it's something to be very cautious of. And the parents don't expect it to happen. They don't understand that that's what it means, but it does happen. And then, of course, we already mentioned there's no contingency beneficiary. So if John and Jane die together, absolutely the property will go through probate. So the second type of property ownership is community property, where 2 people that are married own property together. So that's the distinction. We really like the community property method of titling, because for married couples, it gives them both a capital gains full step up at that first death, which means that it minimizes their capital gains taxes when they go to sell it. And essentially, with this type of co-ownership, you only own 50% of the property. Your husband or wife owns the other 50. So the con to this, the big con to this, and the reason why most people don't choose it during that purchase process, is that it goes through the probate court at first death. So if husband or wife died, there has to be a probate proceeding, a court proceeding to clear title, and it's pretty costly. So the caveat, or the recent law changes, not very recent, but fairly new, that allows you to kind of have the community property tax benefits with the joint tenancy presumptions or probate avoidance, is to take title as community property with right of survivorship. That way you kind of have your cake and eat it too. You get all the tax perks, and at the same time, if something happens to one of you, it doesn't necessarily go through probate. It doesn't have to go through probate to be cleared out, okay? And then the third form of property ownership is tenancy in common, and this is just 2 people who own it, but instead of owning whole, they actually own certain percentages. So 2 buddies who come together and say, okay, I own half, you own half. It's great because you could delineate exactly what percentage of ownership there is. It's a great way to own property with non-spouses, because your share won't automatically go to the other person at your death, like in that first scenario with joint tenants, but rather it just trickles down to your heirs. So that's one of the perks. The cons, of course, are that, again, it goes through probate, so people don't choose it for that reason, which is obviously costly and public. And then we also have, there's no contingent beneficiary provisions that you could put on a deed. So if you're gone, it goes through the probate process. So those are the 3 types of property ownerships, and you can tell that one of them ends up in probate, but the others don't necessarily. So it's to be very cautious about how you decide to take title. So it's not necessarily the case where we have a flat out rule that says if you own property, you have to have a trust so that you can avoid probate. It really does depend on the person's particular scenario. And so this is a question I get asked all the time as well. Should I have a will or a trust? Which one is better? It's not necessarily that one is better than the other, it's that if you have a will, as we learned earlier, you're going to go through the probate process, which is the entire thing that you're trying to avoid at all costs. So the trust is what avoids the probate process. And the trust, I like to describe it to my clients as a basket. We're weaving a basket together. We're designing it however you want to design it. You know, your basket and my basket should look different. So whatever colors and patterns and shapes that are appropriate for your life and your assets. And then we're filling up that basket with everything you own throughout your life, so that when you're gone, there's nothing in your name that needs to go through probate. Everything was in the trust name. So that's kind of the loophole in California that allows people to avoid probate. And so the answer to this question is you actually need both. Legally, you need a will. When we create a trust, what we do is we also have a pour-over will. And the pour-over will is just kind of like my backup document that says, hey, I've already given everything to my trust, but if I forget, I really want everything to be given to my trust at my death. So both of these documents work together, and the trust is the backbone that provides all that probate avoidance. So let's see here. I think I went too far ahead. So one of the other benefits of pre-planning and to eliminate the need to go to probate, as I mentioned before, is guardianships. A lot of times we end up in probate because a child or minor inherits assets, in which case they can't control it until they're 18. So it's kind of locked away in a guardianship account. So when the pre-planning happens, it's always a good idea to utilize that same trust to be able to shape and outline how you want things to work for your kids if you're not there. You're basically saying, you know what, I know it's supposed to go to court, Mr. Judge or Mrs. Judge, I don't want you involved in my kids' affairs. I'm pre-planning what's going to happen. I'm putting these things into this basket and I'm handing it over to my best friend, Jimmy. Jimmy's going to be the one that holds this basket for my kids until they're 25 or 30 years old. And until then, he's going to hold on to the basket and give my kids whatever I've asked him to give. And then at 35, he kind of hands over the basket to my kids and says, here you go, this is the rest of your inheritance. So we're eliminating the need for that court supervision altogether. So the guardianship is the most, I think, important document for parents. It will dictate who will be physically in charge of your child when you're not there, who's going to take care of the child day to day, who's going to decide how they're educated, what religion they follow, what kind of dietary restrictions they have, whether they get vaccinated or not. So all of those very difficult parenting decisions that you make, you're delegating to another human in your life that will be around when you're gone, hopefully, that thinks and talks and walks the same way that you do as a parent. So it's very important to pick somebody that follows your same thought process and ideologies about life. And then you can pick someone totally different to manage the money for your kids. It doesn't necessarily have to be the same human being. And for most of us, that's usually the case, where we have one nurturing person in our life that would be great for the day-to-day things, but that person does not have a financial bone in their body. And so we have to pick someone else that's good with the money, but terrible at nurturing, right?
Right. So
some very few people are very lucky and they have one human that has both sides of that brain and can do both things.
This is one of the things that this is sort of the impetus for people to reach out to us and say, hey, is it time for me to get an estate plan? My wife is pregnant or we're adopting. And I think this is something that we now need to consider. So I know from our standpoint, this is one of the things that comes up and says people are finally realize the need for estate planning. Is that something that you've experienced as well, that having a child or having a child come to the family is one of the reasons that people reach out to you?
Absolutely. I think it's the one big life change that pushes people to start thinking about the process a little bit more. So I have, for example, I have a client who I met with recently. we started off the estate planning process for them with guardianships in mind. That was their primary goal. They did not own real estate. They didn't own any assets that were probatable. They could have, transferred them through other means. So their goal was really to make sure that they have a guardian set in place. And throughout the last several years, they've kind of increased their asset portfolio and recently purchased a home. And so the great thing is that everything was already set up to go. So, them buying a house and going through that expense didn't have the added headache of having to now put together a trust. Their trust was already there. So we just transferred the home into the trust. Everything is set up the way they want. They have the guardianships in place. So I think at the very minimum, if you have a child, even if you have no assets, you should have guardianship nominations in place so that nobody ends up fighting over your kid in probate court. And your kid ends up with the person that you would have wanted to take care of them, not necessarily like your religious, whatever aunt or something.
Right.
Who's going to raise your kid totally different from what you would have done.
That's great.
So I think, but the takeaway would be that you don't need the same person to be in both roles. You can have a separate human being managing the money, and you can have a separate human being managing the child, and they will work together. So the guardian may go up to your trustee and say, hey, I think we've been looking into private schools and that's the way we want to go. And the trustee may say, well, you know what, I think we have enough finances in the trust. We have enough money to make that happen. Or the trustee might say, you know what, if we pay for private schooling all throughout these years, we're not going to have enough for college. And I think that might be more important to hold off on. You live in a really good school district. There's no need to go private. So they kind of have to work together, but the ultimate financial decisions are up to the trustee. And it's kind of like this checks and balance system. With that said, some people have one person that they can name in both of these roles. So if you don't decide, what ends up happening is that a judge decides based on petitions that are submitted. So it's always good to be the one that makes the decisions, in my opinion. I'm just zipping through so quickly here. Okay. This is a fun slide, cousin Sue is going to be the guardian, even though probably Sue's never had children and doesn't know the first thing about taking care of a child. The judge, who doesn't know your family, doesn't know your child, is going to make all of these decisions, which I don't think any mother or father would want. So here are some common estate planning myths that I hear all the time, which is I'm too young. I had my youngest client pass away at the age of 39 from cancer last year. And so that to me is just like this huge example of you're never too young to have it together. If you have children, if you have assets, you need to put a plan together. You're not necessarily, making a determination that you're going to go anytime soon, but at the very least, you pre-planned and made sure to check all your boxes and take care of things for your family. So in his case, when he met with me I think he was about 35 when we did the estate plan, he was he wasn't very open to the process. It was forced on him by his very responsible, business savvy wife. And he was lucky that she was there to kind of push it on them, because they did have a very large asset portfolio that would have cost 6 digits to probate had he not had a trust. So it was well thought out. The planning was done, if I do say so myself, pretty well, so that when he was gone, it was very easy for her to transition over, take some of that life insurance money, take some of the inheritance that he got from her, almost tripling what they had only a few short years before. So that to me was a great example of, not throwing money away in the probate system and reinvesting that money into the kids. The second one I get all the time is I'm not wealthy enough. And I think if you have a life insurance policy in combination with a child under the age of 18, that in itself is enough to require a trust. That's one mistake I see all the time, where parents will designate the child as a beneficiary of their life insurance. To me, that means that when you're gone, that money goes to court, and the court will set up a guardianship account for your child, and then your kid is going to actually get that money at 18, all of it at once. So that's something that we don't want. And then the third one, I have a will, so I don't really need to worry about probate. I think this is the misconception. People do wills thinking that it avoids probate, and then sadly we have to tell the loved ones like, hey, we got to go to probate. So a will does not avoid probate, big takeaway. And then my favorite one is I don't need a lawyer. I could just create an estate plan through a service like LegalZoom or like the jack of all trades attorney down the street. And I say, go right ahead, because that actually generates more work for me in the future. I don't mind at all. But so that I don't like, only because there's so many intricacies within the planning world, so many different tax laws that we want to take advantage of, so many different benefits that we want your children to have at their play if they need it. So special needs planning is like a great example of this, where if you go through a service like LegalZoom and you just create a trust of your own, it's fine. But if you're not asked the right questions during that planning meeting and you have a kid with special needs, whatever you did may disqualify that kid after you're gone. And so you have not really done any service to yourself or your family. You've actually caused more headache and problems than had you just not done it at all, to be honest. So be very careful. I think that's the one thing that I tell people, to be very cautious about how they do their planning.
Yeah, I one of the things I've heard before is that, you don't think you have an estate plan, but you do. It's governed by the state of wherever state you're living in. It just might not be, and more likely than not is not the estate plan that you would have wanted, but it's something is in place. It's just, not what you would have picked. So.
Right.
I believe there's a slide that I don't know if it got jumped over, but there's it sort of explains everything that's involved in a comprehensive estate plan. The trust, the will, the guardianships, power of attorney, all those different things. I didn't know if that's there. If you could spend just a few minutes talking about some of those different provisions on there, because I think a lot of that stuff is good information to pass along to the listener.
Sure. So the way I describe an estate plan is that it's essentially a compilation of different documents that come together and they serve different purposes. So for example, that trust serves as the backbone to avoid probate and to transfer wealth to minors, and to allow you to kind of control from the grave and dictate how things should be done after you're gone. The will, even though you don't necessarily use it, it's still there as a backup for me as the attorney. Because if I let you go after I've done the estate plan and you mess something up in the future, let's say you buy an asset and you don't transfer it into the trust, when I'm in the process of administering the trust, I don't have to necessarily probate that asset that you forgot. I can utilize the will and the general assignment and maybe go into court and do a short petition and ask the court's permission to actually transfer it into the trust ourselves. So there's all these little tiny petition processes and other non-probate procedures in court that we can use. So the will, the general assignment, these are all kind of my backup documents. And then we have a series of power of attorney documents that everyone should have. They cover different things. So the healthcare power of attorney covers medical decisions for the individual, end of life decisions. The financial power of attorney will cover financial decisions that are made. The digital power of attorney will cover anything digital and virtual that is owned by the individual. And all of these powers are actually used when and if the person is disabled. So not necessarily death, but if you are temporarily sick or you're permanently sick, we don't have to go get a conservatorship. We can manage your affairs using these documents. Spousal property agreement, again, it's one of those backup documents for capital gains purposes. So all of these combined form an estate plan that's unique to that couple or that individual's specific needs. Some people may not need all of these, it just depends on what is out there. And then the guardianship, I think we touched on, is the most important one for parents. I personally like to have an independent standalone guardianship nomination so that you can kind of leave around the house when you're on date night or you're on vacation or whatnot, so that if there is an emergency, at least whoever's taking care of your kids has a list of people, temporary people, that the kids go to until your permanent guardian is able to come in and physically be there, so that your children aren't handed over to like CPS if there's a terrible accident and you're gone in a car accident or something and you don't make it home. they actually have a list to go off of. And then there's also the guardianship nominations that are found within the will that will describe to the court who you wanted to manage everything, your day-to-day childcare. So all of these combined form what we call an estate plan, and hopefully it's comprehensive so that it covers every possible scenario and angle that could come up in life.
Wow, I think that's those are some good tips, and I think that I think ultimately what needs to take place is that because each of these individuals and each of these circumstances is so different, the best thing to do is to talk to an estate planning attorney, talk to Armine, and figure out what makes sense for your situation. A cookie cutter solution such as LegalZoom is not the best solution because everybody has a different need that you'll be able to help identify what's important and what's not necessary for that couple or that person. We do have some questions, have a number of questions actually, so I will go through those, and Armine, if you don't mind spending some time answering those, that would be great.
Sure.
Okay, so the first one I have is, how would someone go about transferring title of a home to the remaining joint tenant after the first joint tenant passes away? Does that make sense?
So that's actually a very easy process. So in LA or in any county, it doesn't matter, but the county recorder's office is actually responsible for clearing the joint tenant's name off of title. So if you have two people, one of them's passed away, you would submit an affidavit death of joint tenant with the recorder's office, along with a copy of the death certificate. They will record that in the chain of title. They will redact all the personal information from the death certificate, but it will become a part of the title to the property. And essentially, the deceased person's name will be considered to not be there anymore. So whoever the last man standing is can go ahead and sell and do whatever they need to do.
Great. Okay. Do the items processed via the pour-over will have to be probated before they're transferred into the trust? Oh, that's a good question.
So repeat that one more time. Do the assets that are not in the trust,
right, captured by the pour-over will,
no. So it doesn't. I should preface that with maybe. It depends. It depends on if there are other intent descriptive statements that we can use to go through a Hegstead or an Ukestead petition. So there's other petitions that we can utilize through the probate system that are shorter, like 3-month processes that we could go through. So I'll give you an example. So a client of mine, an administration client of mine, we finished administering her and her husband's trust when the husband passed away. And then a few months later, she discovered that he had an investment account with about $200,000 in it that had no beneficiary designation. It was not held in the trust name, and he had opened it up after he had created a trust. So he should have put it in the trust, but for some reason it was never done. And so that $200,000 account needed to go through a probate proceeding. Well, the estate planning documents were properly prepared, so we could essentially go through, and we ended up doing it this way. We actually went through the probate court, petitioned the court and said, hey, the will says he wanted it to go to the trust. We have this general assignment that says I give all these types of accounts into my trust. So from those two documents, the court can infer his intent, and we can utilize some case law to support that intent, and they will give us permission and give us an order that orders that financial company to release the money to the trust name. Okay. So it's not necessarily a probate. At the end of the day, it costs the client a pretty penny to do it, but not as much as probate. But she was, in the red by a couple of $1,000 in attorney's fees because of the fact that he just forgot, or the advisor didn't, properly advise him. I don't know, whatever the scenario was that controlled that situation.
No, that makes sense.
But it wasn't necessarily, if it's done correctly, if the pour over and the other documents are prepared correctly, then yeah, there doesn't need to be a probate.
Cool. So I think probably a good estate planning attorney such as yourself has one of these put together. But the question is there a checklist as to what a loved one should do after someone passes away in terms of the deceased person's affairs. So
it's a very long checklist.
Yeah, I assumed, but that's something that obviously that would be unique to each individual.
Yeah, so I think it depends on the type of assets we're dealing with, but it really depends. But within the trust administration, I would say, first of all, don't try to administer it alone. You're going to end up wasting time and money trying to do it on your own at the end. It's better to just give it to a professional from the beginning and have them guide you through the administration versus trying to do it yourself, wasting time and money, and then finding out that you can't do it and you need somebody to step in. But
Yeah.
it's always a good idea to work with a professional because they'll have, like you mentioned, we'll have our protocol of what we handle first, what we tell them to do first. But generally speaking, it's securing the properties or the assets, making sure it's insured, safeguarding everything first, and then going through the motions of what the estate plan says needs to be done. Sending out proper notice, filing, lodging the will with the court for safekeeping. There's so many different requirements and notices that need to be given.
This is something that we work together with estate planning attorneys on all the time. Once the unfortunate situation of a loved one passing, sort of figuring out how to change the title of the accounts or transferring the accounts or setting up new accounts, when we're the ones helping manage that, or in the scenario where we're working with somebody on a one-time basis, sort of getting the ducks in a row after the fact, after the person's passed away, and helping them navigate that picture, because a lot of times the information is there, but the understanding of what the process is like to finish it up is not. So just because you know what to do doesn't mean necessarily know how to do it. So that's one of the ways that we help assist in that process as well. So then there's a couple other questions here. Are there any special circumstances for same-sex couples in establishing an estate plan?
I mean, there used to be back in the day before same-sex marriage was legalized. We used to plan in a very particular way, but with legalization, there's no difference in my view. It's a matter of doing it the same way you would do for a heterosexual couple.
Gotcha.
With that said, there are some unique planning questions and considerations. For example, if we have a same-sex couple that designates each other as healthcare agent to make life decisions, right, dealing with their healthcare, and we have one of the individuals who is not on speaking terms with the parents, it's a matter of, well, how much control do you want to give each other as agents? Do you want your partner to control who visits you if you're in pretty bad shape at the hospital or you're on your deathbed? Do you want to have your family have access to you, or do you want to give them permission you want to give your partner permission to control all visitation? So those are kind of the more important conversations that we had before and that we still continue to have. With certain family situations. And again, that is not unique to same-sex couples, but I think it's more prevalent, for example, in the community where not all family members have accepted the couple. So we want to make sure that everything runs smoothly and that no one's filing a crazy petition to set something aside. But the way I see it is it's no different than planning for a heterosexual couple.
Gotcha. Yeah, I mean, that makes perfect sense. As sort of the law has evolved, it made that process a little more straightforward for same-sex couples.
Right.
So how long does the process take to set up an estate plan? It's sort of a two-part question. How long does the process take with you to sort of set up the total estate plan?
It depends on the client. On our end, it takes me about 2 weeks to draft everything after initially meeting with the client, the planning meeting. After 2 weeks, the ball is in the client's court. Some clients review the draft documents and they feel confident enough to sign within weeks. Some clients, it takes, close to a year to circle back with me. It just really depends. And if any of those clients are listening, schedule your appointment.
Get into the office. Okay, so then once it's established, how often do we need to update it, or is it necessary to update it? If I don't move or don't have any more kids, do I need to come in and have it updated, or is it an evergreen document?
It's not it absolutely is not an evergreen document. It always shifts and it should always shift and change according to the laws and according to your life, right? Those are the two things that will require changes. So like you mentioned, if you have a kid, if you buy assets, if you change who you want to be in charge, those are all reasons to make changes to your estate plan. But if you don't have any of that life change happening, there's still good enough reason to check in every so often and make sure the laws are still in your favor. There aren't any new codes that are out there that put you at a disadvantage. Like, for example, years ago, we were doing AB trusts for couples where the trust would be required to split in half at first death. Well, the tax laws are so favorable now for the estate taxes that an AB trust is a hassle to administer for most couples that just don't have that much wealth anymore based on the new tax code, right? With these Trump law changes. So those people should be talking to their attorneys to make revisions or possibly consider changing the type of trust they're dealing with. So it's kind of like the type of car you're driving, right? If you're driving an SUV and you need to change to a sedan because of whatever changes happen in I don't know, terrible analogy, but basically the way I think about the different types of trusts is you're driving a certain type of vehicle, and it's not always advantageous to drive that one type of vehicle.
Yeah, that makes sense. That was a good analogy. What are you talking about?
Yeah, I gotta work on it. We do annual reviews with our clients for free, and the reason we do it for free is because I want to keep that communication open. I don't want them to be deterred from calling me because they're scared of like a 10-minute phone conversation and the bill that they're going to get.
Of course.
So they go and ask their, accountant, or they ask their, mechanic legal advice, and they do something wrong, and then I end up cleaning the mess later and charging them for it, and then they're angry at me. So I really want to keep that open communication. And we do annual check-ins where they'll call me, we'll chit chat, and I'll say, okay, that doesn't sound like you have any changes, and we'll go on our way. And then sometimes there are changes, so it all depends. The trust, again, it's if you want to change the design of the basket, that's when you go into your attorney. If you're putting things in and out, your attorney doesn't even need to be involved. So if you sold a house, I don't need to know about it. If you purchased another one and you purchased it in the name of your trust, great, good for you. There's nothing I should do legally for you at that point.
Gotcha. That makes sense. I think one of the things that we run into all the time too is if you have a power of attorney that's older, too old. It's hard to even to quantify what too old means. But if you have a power of attorney that's too old, the financial, the banks, the custodians and rightfully so in some cases, are a little bit more skeptical of it, and for elder abuse reasons. So they basically scrutinize it a lot more heavily if it's a 5-year-old power of attorney versus one that was done immediately preceding the request or within the last year or so long. I'm sure each institution has their own sort of test as to how long is a fair amount of time to take. But that's one of the ones that comes up on our end, that power of attorneys that should be in good standing for all intents and purposes end up being rejected because they're too old. So.
Right. I totally agree with you on that one.
So then the last question is I think this will be a good tie it up. How do people schedule an appointment with you if they want to learn more or talk to you?
They can contact our office. So that would be probably the easiest way of doing it. Contact our office. We schedule free consultations. We can do the consultation by phone or in person, depending on your convenience. And then we go from there. But essentially, contacting our office is the best way. You can also email me and we'll send you a link to our calendar. And some people prefer that with very little human interaction. We'll send you a link to our calendar and you can look at it and see what works for you and schedule your own consultation appointment.
Great. We just don't want you to charge us. So the least we have to talk to you, the better.
Well, that first meeting is free, so there's no charge.
Oh, great. And then I know Armine is quite a prolific video maker. So she's got a ton of great estate planning advice and information, not legal advice. You can't use it as legal advice, but a lot of great information on her website and on her social media, information that you guys can view and download to sort of get the process started to kind of figure out what the next steps would be for your individual estate plan before going to talk to Armine.
Thanks, Matt.
Yeah, absolutely. So thank you so much for joining us. I think that was an amazing, I was taking notes the whole time. That was an amazing presentation, Armine. You're clearly know exactly what you're doing, and I have the full faith, and I know we've worked together in the past, and I'm full faith and confidence in your abilities in the estate planning arena. So thank you very much for joining us, and Armine, thank you again for your time, and
No problem. Thank you for having me.
definitely.